Talk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright.
Hello, everyone, and welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas.
And I'm Jamie Cudlitz. Welcome back, Chalk and Gavel listeners. Thanks for joining us. We're going to go back to the 1970s with today's case. So get out those platform shoes and disco records, and we'll talk about a parent who took on the state of Texas, challenging the constitutionality of a school funding system that had far-reaching consequences for students from different socioeconomic backgrounds. We're going to dive into the American promise of equal opportunity with the case of San Antonio Independent School District versus Rodriguez. This was one really huge case. And that makes a lot of sense because everything's bigger in Texas. Oh boy.
So the kids are alright. So the kids are alright.
So, Jamie, do you have a bell ringer for us before we jump into the Rodriguez case?
I do. This is a good one, folks. You know, we only talked about this a few episodes ago. In episode 4, we have an update to the complaint that was filed that we talked about in episode 4 with A.V. Very. Okay. So if you remember episode 4, we had a bell ringer where we talked about a teacher in Florida. Their name was A.V. Very, and they used the honorific mix on their email signature as they identified as non-binary, and they were fired, right?
Yeah, they were, if I remember correctly, they were let go by the Florida Virtual School for failing to follow a new Florida law that basically prohibited folks from using or even sharing pronouns that differed from their biological sex at birth.
Right. And so at the time, in episode 4, when we talked about that as a bell ringer, it was just an EEOC complaint, right? And I remember we talked about the fact that this is probably going to go somewhere. And guess what, folks? It's gone somewhere.
It did.
It's now a lawsuit. It is a federal lawsuit that was filed back around the middle of December. And A.V. Very, who also goes by A.V. Schwandez, I'm not sure if I'm pronouncing that correctly.
Another theme of this podcast.
Yes, right. So A.V. Very, A.V. Schwandez, and 2 other teachers filed a federal lawsuit alleging that their rights were being violated by this particular Florida policy. Yeah. And so it's, so now this is going to be in the U.S. District Court of the Northern District of Florida. And the hearing is tentatively scheduled for March 29th. Yeah. So we're going to see how this one plays out. We saw this one coming, and here it is.
Yeah. And I remember in that bell ringer, we talked about how, that Florida law that forbids kind of reporting your pronouns if you're transgender, how that might violate Title VII of the Civil Rights Act because it would be, discrimination based on gender because it's discrimination based on transgender status. And that is one of the claims that they brought.
Yeah.
So, they brought a number of claims here in federal court. So they alleged that the policy violates Title VII, violates Title IX, which we haven't talked about much yet. I guess it came up in our very first episode, which prohibits sex discrimination in educational programs.
Right.
And then also they claim it violates the Equal Protection Clause and the First Amendment. So all things that we have touched on already. But it'll be interesting to see how this plays out.
Totally, because as you mentioned in episode 4, the schools and the districts are potentially caught between a rock and a hard place here because they've got potentially conflicting legal obligations between the state and federal. And one of the interesting things about this is that, again, this was a case of a teacher who put MX in their email signature. Okay. This was not a case of a teacher standing up and preaching or advocating or whatever. This was the teacher doing the same thing that any other teacher would do when they put Mr. or Mrs. in their email signature, and so it will be very interesting to see, and I guess that's the equal protection piece of the claim, is how they are being treated differently because there are now different expectations for a particular class of people, right? And it has been recognized in Bostock versus Clayton County as a protected class, right?
Under Title VII, yeah.
Under Title VII. So this is going to be, I don't know. I am predicting this is going to have pretty major implications, because it's either going to strike down this law in Florida, which is going to have far-reaching implications beyond Florida, right?
Right.
Because a lot of states have this. Or it's going to at least provide a degree of guidance that will allow states to potentially make some of those policies a little less ambiguous and a little bit more clearly defined.
Right.
That's potentially an outcome here. Or who knows? This could go all the way to the top. You never know.
It could. And we'll report back internet when that happens in 2 to 3 years.
Yeah, no. We'll keep you updated before then. Don't worry. Okay. So anything else we want to say on that one?
No, I think we're good.
Let's dive into San Antonio versus Rodriguez. How does that sound?
I'm here for it.
Yeah, I don't want to do this alone, so that's good. Okay, so San Antonio versus Rodriguez, it was a landmark Supreme Court decision that really shaped the landscape of educational equity in the United States. We're talking about a time when the debate over equal access to quality education and the educational rights of students was at one of its highest points in history. This case sparked a legal battle that continues to resonate in discussions about fairness, opportunity, and access in education. One of the reasons is because school funding is really complicated. So everybody, please put on your math hats. Lots of cases on this topic continue to this day, but San Antonio versus Rodriguez was one of the first. So let's dive into the facts here.
One of the first, and also the word from the Supreme Court of the United States, at least. So because of San Antonio versus Rodriguez, a lot of these cases are now being litigated in state courts. So this is kind of the big federal case in this whole domain.
Exactly. And not to give it away, but one of the big outcomes here was that the Supreme Court basically said, all right, states, we're not getting involved in this kind of stuff. So you're on your own.
Right.
Okay. So so that's why a lot of this stuff is playing out, with cases in North Carolina, for example, with the Leandro case that's been going on for 30 years. It's not going to go to the Supreme Court, U.S. Supreme Court, most likely, because of the Rodriguez case and how the Supreme Court ruled, right?
Right.
So, all right. So here are the facts. So the case originated in the Edgewood Independent School District, which is an urban school district in San Antonio, Texas. Essentially, there were poor minority students living in districts with a low property tax base. And until recently, Texas was a predominantly rural state, and its population and property wealth were spread pretty evenly across the state. So as the state became more industrialized and as rural to urban population shifts became more pronounced, there were increased differences in the value of property between local school districts. Makes perfect sense. Happens everywhere, right? Property values are different all over the place. So what that meant was that the amount of tax resources available to each school district started to change.
Right. And that's the key piece here. Because these districts have a low property base to draw on, that's how we fund public schools, right? So we fund public schools in large portion through local property taxes.
Right.
And so if you've got inequalities in kind of the value of the local property, then you're going to have inequalities in school funding. And so that's kind of the underlying thing of this case is when you've got inequalities in your taxable property base, you're going to have inequalities in school expenditures and school funding unless the state or the federal government balances that out.
Right. Which is what Texas was trying to do with what they called the Texas Minimum Foundation School Program, which started in the 1940s.
Rolls off the tongue.
Yeah, it does. The Texas Minimum Foundation School Program. So that program now accounts for about half of the total educational expenditures in the state.
And that's pretty typical. So we're talking about what was current in 1973 when this case came about. But today, the number fluctuates a little bit, but typically around kind of the national average, half of funds come from the state, 40% of funds come from the local level, so local property taxes, and then 10% of funds come through the federal government. So that's typically the breakdown. Obviously, there's a little bit of play, and it's very state specific. So some states look totally different. Right. But general rule, 50 state, 40% local, 10% federal. So you can see that 40% makes a big difference.
Right. Yeah. So if you've got a really, really wealthy district with high property values, it's going to lead to a much higher tax revenue than a district with very low property values, right?
Mm-hmm.
So what happened was this program was established in Texas to try to even that out a little bit.
Or at the very least to reduce reliance on local property taxes.
Exactly. So that program basically earmarked money for teacher salaries, operating expenses, transportation. So huge chunks of school budgets were coming from this particular program. So putting into this minimum foundation school program, the state provided about 80% and the school districts provided about 20%. The 20% that came from the school districts was called the local fund assignment. And it was split amongst all the districts using some kind of math formula.
Is that your math hat?
That's my math hat. That's about as mathy as we're going to get on this show today. So those of you who are still tuning in, after
they heard numbers and they turned it off.
Yeah, when I said, put on your math hats, they were like, okay, I'm done.
So essentially what happens is the state is giving districts a pot of money. And in order to fund that pot of money that the state is giving districts, the state puts in 80% of that money, but then a part of that comes from the districts themselves.
Right.
So the districts have to pay the state for the state then to pay out. The amount they get back is significantly higher than what they're paying to the state.
Yeah. So basically that formula that determines how much a school district needs to put into that fund is designed to reflect each district's relative tax-paying ability.
Okay.
Right? So basically, the state is saying, every district, you have to put money into this fund. All right? And then from this fund, we're going to give you back a big chunk of money for you to run your education program, right?
And then the really, I think, important piece of that is school districts are free to tax themselves above what they're required to provide for the local fund assignment to the state. And so that's kind of where the local revenue comes from, is if they want to tax themselves above what the local fund assignment requires. And at the time of San Antonio versus Rodriguez, every district in Texas taxed themselves above what they had to pay to the local fund assignment. So every single school district had local taxes in addition to what the state was providing.
And this is where the disparity comes into play.
Right.
And we're going to use what this particular lawsuit used. They compared two districts. And so we're going to use this comparison to help illustrate the disparity that brought on this lawsuit. So basically, the lawsuit called attention to two school districts, the Edgewood Independent School District, as I mentioned earlier, and the Alamo Heights School District, okay?
And the reason that these two districts were compared to each other is because these are the least and most affluent school districts in the San Antonio area.
Right.
So these districts are pretty close together geographically, right? They're close together geographically. But
yes.
As Jamie's about to reveal, they are miles apart economically.
Yes. And thank you for that very important context.
That's why there's two of us.
That's right. I told you I couldn't do this alone. All right. So, so Edgewood and Alamo, close together, very low income, very high income kind of districts. Okay. So Edgewood, much bigger, 22,000 students, 25 schools, and a very high minority population, 90% Mexican American, 6% African American, whereas Alamo Heights was 18% Mexican American and less than 1% African American. Okay. So these districts on a number of metrics looked very different. So the average assessed property value per student in Edgewood was about $6,000. The average assessed property value per student in Alamo Heights was about $50,000.
Wow.
Yeah.
That's a huge difference.
Massive. All right. So basically, what this amounted to was Edgewood got about $356 per student. Alamo Heights got almost $600 per student from this fund. Okay. It's because Alamo was able to raise a lot more money based on its property taxes.
Yeah.
Right?
Yeah. So looking at like, basically, where is this money coming from, right? Like Edgewood is getting $108 per student from federal funds, $222 per student from the state. So that's the foundation grant. And then they're raising an additional, $26?
$26. Yeah. And Alamo Heights was able to contribute $333
from local property taxes.
From local property taxes.
So over $300 more from local property taxes just because of the property value within the district.
Yes. So what that amounted to was Alamo Heights and their 5,000 students, very small number of students compared to Edgewood, would get almost $600 per student from this fund, whereas Edgewood's 22,000 students would only get about $350 per student from this fund.
Okay. So, that's not quite twice as much, but it's
close. It's a lot.
Yeah, that's huge. That's a huge difference.
Right.
And the thing that floors me about this is it all comes down to the value of the local property. Because Edgewood, they can only raise $26 in additional revenue per student based on their local tax property base, but they're taxing themselves at a higher rate. So they're taxing themselves at $1.05 per $100 of assessed property. Alamo Heights is taxing themselves at a tax rate of 0.85%.
They're getting taxed less.
They have a lower tax rate and they're making
so much more.
Way, way, way more. So like if we're looking at like who values education more, there's an argument here that the people in Edgewood value education more because they're willing to pay a higher proportion for their education, but they're only able to make significantly less because you can't squeeze blood out of a stone, right?
Right. So, this ultimately just comes down to how much more one district can raise over another. So Rodriguez's kids were in the Edgewood Independent School District. And guess what, Chris?
Did they file a lawsuit?
They did, because they weren't happy about what they were getting compared to what the students in a district like Alamo Heights were getting.
Sure. And these are pretty stark inequalities, right?
Right.
So they bring this in federal court, and it's based on the Equal Protection Clause to the 14th Amendment of the United States Constitution. And essentially, the argument they're making is that these inequalities between Edgewood and the surrounding districts, because they are predicated on the difference in property value within the district, these violate the Equal Protection Clause because they either intentionally discriminate against poor families or they deny a fundamental right to education. And those are kind of the theories that Rodriguez and the other plaintiffs are bringing here. Is the funding system violates the Equal Protection Clause because these inequalities are unconstitutional.
Okay.
And the district court agrees. And that's big. So the district court rules that Texas's school funding system violates the Constitution because wealth is a suspect classification and education is a fundamental interest, both of which heighten kind of the judicial scrutiny with which they analyze these laws. And under that heightened level of scrutiny, Texas's funding system can't survive. But interestingly, the district court, so it makes this landmark decision that Texas's school funding system violates the Constitution. But it does something really interesting. it stays its decision for 2 years to allow the Texas legislature a chance to remedy the inequalities. And the court basically retained jurisdiction and said, hey, if you don't do this within 2 years, I'm going to fashion my own remedy. So you better fix this. Of course, that never ends up happening, though, because this gets appealed to the United States Supreme Court.
Okay.
And this is one of those cases where we have a lot of opinions and it's a really close call. So it ends up being a 5-4 decision. So 5 of the justices side with the state of Texas, and they hold that this system of school funding does not violate the Constitution. On the other hand, you've got 4 justices who, for different reasons, would have found that it does violate the Constitution. So we're 1 vote away from Texas's system being declared unconstitutional, but that doesn't happen. And we've got 5 justices who did uphold the program.
Okay.
And really, at the Supreme Court, there's really just kind of one issue. And that issue is, what level of scrutiny do we apply to this law under the Equal Protection Clause? So the Equal Protection Clause, the way it's been interpreted by courts is there are different levels of scrutiny, or courts will look at laws and policies with different levels of expectation for how to justify those laws based on how those laws distinguish between people or classes of people. And so laws that are based on race or based on these other kind of suspect classifications, those are subject to higher levels of judicial scrutiny. So courts are going to look at those really, really closely to make sure that they are justified and that the government isn't just trying to discriminate against these groups, either based on animus or whatever it might be. And so that's kind of the question here is, how closely should the court look at this funding system? Should it apply that highest level of scrutiny, which is called strict scrutiny? And if it does, then the state has to prove that its funding system is necessary to achieve some compelling governmental interest. If the court isn't going to apply strict scrutiny, though, then typically what will happen is it'll apply rational basis review, which asks really just, is this program rationally related to a legitimate governmental interest? And that's a very easy standard to meet, whereas strict scrutiny, very, very hard to meet. And so the question is, basically, where on the spectrum do we fall? And the plaintiffs make 2 arguments for why they should have heightened scrutiny applied here. One, wealth is a suspect class. So we need to elevate scrutiny because this law discriminates against us because we're poor. And that is problematic. And then the other one is that education ought to be viewed as a fundamental right. And when the state denies a fundamental right, that's another reason to elevate scrutiny. And so the court looks at both of those theories and ends up basically rejecting both theories and refusing to apply heightened scrutiny to these claims.
Okay.
So turning to that first potential reason to elevate scrutiny, is this unconstitutional wealth-based discrimination? And the court looks at this and says, you know what? Wealth alone doesn't seem like a sufficient classification to justify elevating scrutiny. So for the Supreme Court, the way they kind of look to find if a group is a suspect class that is deserving of heightened judicial protection is to look at what they call the traditional indicia of suspectedness.
Oh, boy.
Yeah. Right? Did I say indicia? Indicia?
No, I don't know. I mean, like, seriously. Come on, court.
Well, they've got a thesaurus on hand, right? So they're looking at the traditional indicia of suspectedness. So here are the kind of criteria they look for to decide whether or not a group is deserving of heightened protection. And the classic examples of this are race, sex gets intermediate scrutiny because it kind of falls in the middle between these different kinds of suspectedness. But they look to whether or not, and this is a direct quote from the court, whether or not the class is saddled with such disabilities or subjected to such a history of purposeful unequal treatment or relegated to such a position of political powerlessness as to command extraordinary protection from the majoritarian political process. And so the things that they're looking for here are a history of unequal treatment, whether or not the group is able to kind of achieve its goals through the political process, and whether, there are kind of barriers to them achieving those goals based on societal inequalities and historical discrimination.
Gotcha.
And the court basically says that those things are missing when we're thinking about wealth as a potential suspect class. First is, at least in this case, it's really hard to define the class according to the majority. It could be all people who fall below some poverty threshold. It could be people who are relatively poorer than others. So again, comparing Edgewood to Alamo Heights.
Yeah, based on location, for example, like, your dollars go further in some places than they do in others. And
Yeah. Or it could be people who reside in property poor districts.
Right.
And so the court kind of looks at all of these potential ways to define the class of people and says, that doesn't really work for us because not all poor people live in poor districts, and not all poor districts are full of only low-income families. So there's this like over and under inclusiveness issue. But the big thing is that the court is looking at this and is thinking about the nature of the deprivation here. And it's not an absolute deprivation, right? The kids in these districts are still getting some education, according to the court.
Yeah, right.
They're not being completely denied an education. And so the court, has this idea that this is a relative deprivation rather than an absolute deprivation.
Okay.
And so because we can't define the class and because this isn't a complete denial, we're really not looking at a good enough reason to elevate scrutiny.
Okay.
And the dissents obviously take them to task for that, right? Because the dissents say there's a pretty identifiable class here. It is a class of people who live in property poor districts who send their kids to public schools. Like that's a pretty easy thing to define. But then, how do you define property poor districts?
Yeah.
You have to do it compared to something, right? Like how do you draw the line?
Right.
But two things that I'll say that are really interesting here. In one of the lines, the court says that however described, it is clear that Appelli's suit asks this court to extend its most exacting scrutiny to review a system that allegedly discriminates against a large, diverse, and amorphous class, unified only by the common factor of residence in districts that happen to have a less taxable wealth than other districts. And so that kind of, wraps up what they're saying right here.
Yeah. Like, hey, well, I'm sorry. You happen to have less money? Well, whatever.
Yeah, it just kind of happened. It's just this thing. And to me, that language that, Jamie, you and I kind of chuckled at, like, that happened. Like, these inequalities didn't just happen, right? Like, that phrase in the court completely ignore a history here of, really complicated discrimination, redlining, whatever it might be, that kind of led to these housing patterns. So like, I think it's disingenuous to view these housing patterns as
like happenstance.
Right. Exactly. Yeah. They happen for a reason. And that's an amalgamation of both individual choices.
Or a bunch of reasons.
Right.
Yeah.
And policy decisions, right? Like the policy decisions created these inequalities. So, that's one point that I want to push back on the court a little bit for that one.
I get it.
And then the court also repeats throughout the opinion this question of whether money matters in education or not. To me, that doesn't really pass the smell test.
Yeah. Is it really? Do we really need it? Is it really a thing? I don't know. Whatever.
And that's the question, like, does more money lead to a better education? My response is ask anybody if they want less money. And
look, and we're going to, we'll talk about other cases, in upcoming episodes, like some of the current cases that are going on that have to do with school funding. And, one of the cases, for example, it's a big case in North Carolina, Leandro. It's all about whether or not the state was able to meet its obligation to provide a sound basic education to all of its students. And one of the, I wouldn't say end results because the case is not done yet, but like money is a significant piece of that. There's a lot of stuff that needs to be done in order to provide students with a sound basic education. And that stuff costs money.
Right.
But hey, the Supreme Court is like, is money really a thing?
Well, and so this is a direct line from the Supreme Court. Apart from the unsettled and disputed question whether the quality of education may be determined by the amount of money expended for it, a sufficient answer to Appelli's argument is that, at least where wealth is involved, the Equal Protection Clause does not require absolute equality or precisely equal advantages. And so that's kind of how they come down on the question of whether or not this constitutes wealth discrimination. They kind of say, like, one, we don't even know if money matters in education. And two, the Equal Protection Clause, when it comes to wealth, doesn't really require us to ensure absolute equality. So we're not going to elevate scrutiny based on wealth discrimination.
Yeah.
So then the other potential reason to elevate scrutiny here would be based on a potential fundamental right to education. And, whether or not education is a right guaranteed by the Constitution is a really significant question, right? Because if it's guaranteed by the Constitution, you can't deny it without meeting this really high level of scrutiny.
Okay.
And the court declines to recognize education as a fundamental right under the Constitution, the U.S. Constitution at least. So in order to determine whether or not a right is fundamental, according to the court, you can't just look to its relative social significance compared to other needs or even other rights. You can't compare it to those other things that we've recognized as fundamental rights. For the court, it just comes back to the simple question of, is it in the Constitution? Or is it implicitly guaranteed by the Constitution based on the rights that are specifically enumerated in the Constitution?
Okay.
And so this is a pretty narrow test because the Constitution is really pretty short. And other than the Bill of Rights, it doesn't really guarantee a lot of rights to citizens or to individuals. And so the court looks at this and says, you know what? Education, I did Control F. I didn't find it. It's not in the document. Education isn't mentioned in the Constitution.
Right.
And then it answers that question of like, well, is it implicit in the Constitution based on its connection to other rights? And the court says maybe a little bit, but not enough for us to protect it and not enough for us to be able to draw a line between education and other interests that also may influence whether people can exercise their rights.
Yeah.
And so they address what they call the nexus theory, that education is essential to exercise the freedom of speech and to exercise the right to vote. And that makes a lot of sense, right? Like one of the primary justifications for education in our society is to prepare people to be citizens. And
yes.
Two huge parts of being a citizen is voting and being able to kind of articulate and engage in these larger policy discussions.
Right.
And the court says, yeah, it might have that connection, but according to the court, and this is another direct quote that gets to kind of that absolutist language that we heard from the last, when it came to wealth discrimination, the court says, we have never presumed to possess either the ability or the authority to guarantee to the citizenry the most effective speech or the most informed electoral choice.
Wow.
Yeah. And so you can see the Supreme Court doing some really interesting things with rhetoric here. Most effective, most informed, absolute equality.
Yeah.
Right. All of these are
very deliberate word choices.
Right.
There are some places where we want to be really objective and, really precise and leave no room for misinterpretation. And then there's other places where we want to deliberately say, whatever. Like maybe, maybe not, like very subjective kinds of word choices.
Right. And they make this incredibly high bar and basically then just say the plaintiffs hadn't met it yet.
Yeah.
When, I don't think that's the bar that the plaintiffs were shooting for. And it seems like the court is more concerned about the implications here of what it would mean if they did recognize a fundamental right to education or if they did allow wealth as a suspect class.
They're like, it's like they're basically saying, we recognize that one of the purposes of education is to create informed citizens so that they can participate in our democracy, right? And at the same time, they're saying, while we recognize that, it's really not our job and we really can't guarantee that.
And, I guess to give the court some slack, they can't, right? Like that is so far beyond their institutional knowledge.
I get it. I totally get it. I wasn't saying that necessarily to be critical of the court.
It's okay.
But, it was more of like, this is something that the court said, right? Which is, I guess, one of the reasons why they ended up pushing this responsibility back down to the state.
Right. Yeah. And that's kind of what the court's ultimate decision here is, basically to maintain the status quo.
Yeah.
Right. And to not rock the boat. I will say the court leaves the door open to the potential for a right to a minimally adequate education. So they've got this line that they say, even if it were conceded that some identifiable quantum of education is a constitutionally protected prerequisite to the meaningful exercise of either free speech or the right to vote, we have no indication that the present levels of educational expenditures in Texas provide an education that falls short. And that's really important. So the door is still open to a potential
Yeah.
right to education, but that right to education isn't going to be based on, equal protection. It's going to be based on whether or not it's a fundamental right under substantive due process to some minimally basic education. So the court decides in San Antonio not to elevate scrutiny for wealth discrimination, not because it's a fundamental right. And then they do something really, really interesting here. They end the opinion with what they call a postscript that just kind of talks about the practical implications if they were to come out the other way.
Okay.
And the court says, there's a lot of practical reasons. One, if they found against Texas here, every state in the country is going to have to redo their school funding.
Yeah.
And that's a big deal. Like that would be really, really, that'd be a big shakeup to this.
Okay.
And then they say, this isn't really about a deprivation. This is about affirmatively receiving something from the government. So it's a difference between kind of positive and negative rights, where a negative right is basically freedom from, and a positive right is freedom to. So like, you're entitled to something rather than protected from somebody infringing on your rights.
Right.
And then they talk about how, this would raise really thorny issues about the court's role, their expertise, issues of federalism, so the balance of power between states and the federal government, and then also issues of separation of power about like kind of the role that courts play as compared to the legislature. But the court ends with this wonderful line, or it's near the conclusion. The court assures us, the reader, that these practical considerations, of course, play no role in the adjudication of the constitutional issues presented here. I find that very interesting. Then why'd you mention it?
Yeah.
The bottom line is, they decline to recognize education as a fundamental right. They don't elevate scrutiny based on wealth discrimination, so they apply rational basis. And rational basis is a pretty easy standard to meet. Here, it meets rational basis, according to the court, because the funding scheme balances two interests. It provides for a basic education for all children, according to the state, and it encourages local control of education. And the court says that local control of education, we want education because it's so context specific. It is kind of a accumulation of communal values. It's how we inculcate those values to the next generation of people. Like that's a very local thing. And so we want to increase or protect or encourage local control. The funding system allows for local control because it gives you freedom to devote more money to the education of your children if you want to increase your taxes above what the state provides you. And it, allows you to make decisions at the local level rather than at the state level about what to do with those local tax dollars. So that's the majority's opinion. The dissents really take the majority to task for that. So one of the primary dissents here is by Justice White, and he's joined by two other justices. So this is an opinion that got 3 votes. Justice White essentially says, this doesn't really advance the state's interest in local control because some communities are more free than others to raise additional revenue. So this is kind of like a false promise here.
Yeah.
You're claiming local control, but there's no rational connection between, say, the local control of Edgewood versus the local control of Alamo Heights.
Yeah.
Edgewood can't raise more money.
Right.
So in Justice White's dissent, he says, the difficulty with the Texas system, however, is that it provides a meaningful option to Alamo Heights and like school districts, but almost none to Edgewood and those other districts with a low per pupil real estate tax base. So essentially, Alamo Heights has local control. Edgewood doesn't. And so Justice White would have found that this violates the Equal Protection Clause because it doesn't have a rational relation to that stated interest of local control.
Right.
And Justice Thurgood Marshall, who also dissents in this case, he goes even further and essentially says that Texas is using local control as a justification and not as a reason because the state of Texas infringes on local control left and right. They decide what textbooks you can use. They have a ton of regulations that schools have to follow. So, if they were really into local control, Texas itself wouldn't have intruded so far into the operations of local schools.
Exactly.
And so Justice Marshall, he's joined by another justice, but in his dissent, he would have found education to be a fundamental right. So we have 2 votes for a fundamental right to education here.
That's not enough.
You need 3 more, right? You need 5. But like I said, 4 votes for striking down Texas's funding scheme for some reason. Justice Marshall would have done it because it violates a fundamental right to education and it doesn't meet strict scrutiny. Justice White would have done it without elevating scrutiny. He would have found that it violates rational basis, but they were in the minority opinion and the majority controls, right?
That's what happens.
Mm-hmm.
It's an interesting case. So, I mean, the big takeaways here, as you said, wealth is not a protected class. So that was big. Education is also not a fundamental right under the U.S. Constitution. It may be under the state constitution, which is one of the reasons why there has been such a shift in all of this litigation about funding issues in states, right?
Mm-hmm.
But that's all determined by how things are written in these state constitutions, right?
Right. Yeah. Because that's what San Antonio versus Rodriguez does, is it kind of closes the door to the federal courts to making these kind of funding challenges.
Right.
But every state court includes education.
Yes.
They all have education clauses.
Every state constitution, right?
Yes,
Yeah.
every state constitution. So if you're going back to whether or not something is explicitly or implicitly guaranteed by the Constitution, that seems to be a nice big old checkbox for these states.
The other big takeaway is that the Supreme Court basically said, is there a right to a basic minimal education? Maybe.
Mm-hmm.
There just might be, right?
Right.
So that, they left the door open for that. But like we said about how this is all kind of under state jurisdiction at this point, even though this case was in the 1970s, this is one of the reasons why there are tons of cases going on right now
Mm-hmm.
and have been for decades about school funding issues and equity and access to quality education. And if you look in educational blogs or Education Week, the articles that they put out, like there's a ton of stuff on a regular basis that has to do with school funding
Mm-hmm.
issues and whether or not they're constitutional. Like there was something recently last year in Pennsylvania where a judge ruled that the state dramatically underfunds schools in low wealth areas.
Mm-hmm.
There was more recently in New Hampshire, a judge declared that the state's base aid to school districts was far too low and that a state level property tax policy gives wealthy school districts an unfair advantage.
Mm-hmm.
There was a report by the Education Law Center in 2023 called Making the Grade, and it talked about how fair school funding is in all of the different states. And it basically said it's not in a lot of states.
Right.
So this stuff is like, it's all over the place. And this is being heavily litigated
Mm-hmm.
across the country. And we're going to talk about some of those cases. We're going to talk in a little bit. We're going to talk about the Leandro case in North Carolina, which has been going on for about 30 years now.
Mm-hmm.
This is big stuff, folks. Lots going on in school finance.
Mm-hmm.
Yeah, so there you go. San Antonio versus Rodriguez. We hope you liked it. We hope we didn't make your brains hurt too much. We tried to go a little light on the math.
Mm-hmm.
Okay, it's homework time. What do we got?
For your homework, get your math hat dry cleaned. And then you can find Chalk and Gavel wherever you find your podcasts. Please like, review, subscribe. We really appreciate it. You can find us on social media and at our website. So social media, we're at Chalk and Gavel. Our website is chalkandgavel.com.
So that does it for this episode of Chalk and Gavel. Thank you so much for listening, everybody. I'm Jamie Cudlitz.
And I'm Chris Thomas.
Join us in 2 weeks, and we'll continue to explore how the courtroom is connected to the classroom. See you then.